Hey, ladies and gentlemen, most welcome to Amity Realtors Chats. I don't know if you guys can hear me well, but you're most welcome. Today's conversation is one that is very, very important. So I'll ask you, ladies and gentlemen, if you have just joined in, please go ahead and share the conversation on your timelines. And also, if you have any questions already about the topic which we've been talking about to be discussing this week, please go ahead and make use of the comment box on your right hand corner down there. So, most welcome. I'm just going to be waiting for my guest speaker to be joining me very, very shortly. Hey, Bigger Boy, how are you doing? Is this the Bigger Boy I know who is... Oh, Rocky, how you doing, man? Very, very long time. So, Doreen, how are you? Um, Guys, you're most welcome to the show. Definitely, as usual, please do go ahead and I encourage you to take notes as we go on with our discussion. And also, if you know someone that may be interested in this topic we're going to discuss today, obtaining a certificate of title, steps and procedures, that's what we're going to be discussing. So, right now, I see my guest speaker is here. I'm gonna let him in, and then we see if our audio is actually good enough to let us kickstart. Council, can you hear me? Oh, good evening. How are you doing?
I'm okay. How have you been?
Fantastic, fantastic. Kampala is a bit hot and yeah, but you know the usual struggles a common man goes through in this country. How is Zimbabwe? How have you been since the last time we spoke?
We have been fine. We've not had any serious challenges. Uh, we are moving on. People have enjoyed the Easter festivities. Those who have been worshiping, we worshipped. Those who have been relaxed. Those who have been catching up with lots of their work, friends. It's all come to an end, and we are back to the hustle.
Yeah, fantastic. Meanwhile, last week we didn't. I think we went off air without wishing our listeners a happy Easter. It was a bit far away, but I hope our listeners really had a fantastic time and enjoyed that long public holiday, which is more or less like half a week of public holiday. Um, so, Council, today we're discussing a very, very important topic. But before we go on to today's topic, I just want to introduce to you, ladies and gentlemen, that we have been holding sessions with Council Alan. For those of you that might not know him, yes, we will ask him to reintroduce himself in case you're new and you don't know who he is. But we have been discussing issues regarding land matters, and we've been having very fantastic conversations, I think, for the last 6 weeks. And today is our seventh episode, which is actually titled Obtaining a Certificate of Title, Steps and Procedures. But, Council, before we go any further ado, maybe I would ask you to reintroduce yourself to someone who will be listening to this episode later on, and also maybe to those who are new on this space.
Thank you, Fred. And let me also take this opportunity to welcome back our dear colleagues, listeners, and friends from the festive season that they have been in from the Easter holiday. And we hope that the risen Christ will strengthen us more in our trials as we emulate Him and know that having died, beat the battle of death and rose again. So let's not give up and keep doing what we do. My name is Alan Musasire. I am a lawyer by profession. I boast of almost 10 years experience in the legal profession. I am a researcher and I also write. I do editing. I am managing partner at Katembeko and Company Advocates, which is based in Imbarara. It is actually the oldest law firm in Imbara, could be about the oldest in the country, having started in 1979. And I am the managing partner of this law firm. Elsewhere, I serve as a youth leader, but I also sit on the Uganda Law Society Governing Council representing the Western region. I am a family man and I have children and a wife. Uh, Basically, that's me. Thank you, Fred.
Fantastic. So, for those of you that do not also know, this conversation has been powered by Amity Realtors, a real estate agency in Western Uganda, helping you find the most affordable yet best land on the market. So, if you're out there looking for agricultural land, if you're looking for commercial land, and maybe simple land to do your farming or simple land to set up your house, please, I encourage you to reach out to Amity Realtors. They'll help you get the genuine value out of your hard-earned money. And they are also actually on the spaces. So if you're already tuned in, please go ahead and follow them so you can have a conversation with them after this episode. Now, Council, allow me to just use 1 minute to do a recap of the 6 episodes that we have done. And for people who are listening in today to know what kind of background we've had to where we are going to be discussing today. So in our first episode, we discussed buying untitled land, a lawyer's advice, and that was our first episode. Then the second episode, we also discussed the role of a will in land management. Then the third episode, we had key aspects of joint ownership of land in Uganda. Number 5, which was episode 5, we had getting over a dubious land deal. This was a very interesting conversation. I remember I really, really enjoyed it that much. And number 6, which was episode 6, this is last week, procedures and steps for management of property of the deceased. Tonight, we're going to be discussing obtaining a certificate of title, steps, and procedures. But before we go on to tonight's topic, Council, would you just give us a simple recap of some of the things we've discussed from where we started from to where we are today? Would you just give us maybe a recap for the listeners to just have a journey that we have been walking since we started?
Thank you, Fred. To all our dear listeners, and we appreciate the fact that you tune in. Yes, we understand not very many people are interested in learning. Some people be out there and they are speaking with a lot of ignorance. And Africans, we've always been known for sharing knowledge. But if you take time off your busy schedules, I know it's always an evening, you have tight schedules to beat. Probably you're already booked up by the day's work. So if you spare time and say, I'll pick a few from this space, I think it is worth it. We appreciate. But to take you through briefly, those of you who have probably not been with us, we have the first session we discussed, like Fred has told us, we encouraged and advised that before you think of buying untitled land, make sure you have done all your due diligences. And when we talk about due diligences, we are saying do every inquiry that there needs to be done. Gone are the days of trusting our relatives, our friends, or even our business associates when it comes to dealing with land, because you realize that the monies involved are usually huge, and land is a factor of production, save for some people who today are operating basically online, but nothing else that will move on in this economy without land. So imagine you have bought this land, you have invested in it, and then a day or two somebody comes and says, please, the land you bought or the title you have is actually fraudulent or it was a dubious deal. So we also encourage people that once you have bought that untitled land, endeavor to occupy that land and do not rely on property brokers, but be sure to rely on established real estate agencies and companies. We moved on to the topic of joint ownership of lands, and here we encourage people that always distinguish between a joint ownership or joint tenancy with a tenancy in common, we realized that this would be very good, but where parties are not aware of what is going on or what is being registered, you are bound to suffer. We distinguish a joint tenants or with a tenancy in common to simply mean that a joint tenancy is where two people appear on a certificate of title and these two people own this land jointly. The key aspect that distinguishes this kind of tenancy is that once one person dies and leaves another on the title, the deceased person does not have an estate in that title. The deceased person's share does not pass to the estate of the deceased. Whatever remains of that title goes to whoever remains registered on that title. That was the joint tenancy. And we told people that this looks a very good thing, but many people have abused it and have misused it. Secondly, we say that tenancy in common is where people are registered on the title, but there are other factors, probably by express writing or by usage or even by contribution. It appears that they are not, they each has an individual share. And with this, there is a right of survivorship, meaning even if I die and I am registered with another person on this piece of land, my estate, my share will revert to my estate. So we encourage people here to always engage services of professionals, especially lawyers, as we have always advised, and always be clear in their dealings, what they need to do and what each other's interests are. When we talked about getting over dubious land deals, we advise people on the need to always lodge caveats, whether with the Register of Land Titles or even physical caveats, passing ready announcements, that we noted that in cases of titled land, endeavor to always indicate an address in your caveat documents, because unless you do, such caveat may not be accepted and there's no way somebody will reach out to you. We talked about going to court, knowing which court to go to for remedy in case you have been duped in a land deal. Let me use that word, or in case you face challenges in the land deal you have been going through. So you need to know which court to go to. We discussed the various jurisdictions of court. A magistrate grade 1 cannot go beyond jurisdiction over 20 million. Land must be below 20 million shillings, and then a chief magistrate will not go beyond land whose value is above 50 million shillings. Then high court has that original unlimited jurisdiction, but it will always want cases that begin with 50 million shillings. For cases involving land titles, we advised parties to always use the High Court because it is the only one that will have powers to cancel such a certificate of title. Of course, the exceptions that we discussed, for example, land that is wholly customarily owned, that can be handled by any other court that is below the High Court. Then when we went to the management of property of the deceased, here we encouraged people at whatever age, as long as they're above 18 and they have properties, they don't have to be quite a lot, quite a number. The moment you have a property and children, it is always advisable to write a will. The fear was that counsel, when I write a will, I am dead. I am a dead man, I'm going to die tomorrow. But we advised uh, our listeners that look, writing a will does not mean you're going to die, and you have the right to change that will as long as you are not yet dead. So we advise clients that look, rather our listeners that look, when you write a will, endeavor that you have listed all your children, give everybody property, let that will be witnessed by people who are not given property in that will, and endeavor to appoint an executor of that will who is neither beneficiary nor a witness. We also encourage people to keep triplicates of these wills. Whenever you make any document, not only a will, here we stressed it that look, always make it in 3 copies, such that when somebody brings a copy, it is the same and there can be comparison. In case one loses their copy, another one is available. Briefly, Fred, that is what I can recap. I think that is good background for those of you who have not been with us, but those who have been with us know and remember that those are some of the key things that we have discussed here before.
Fantastic. Thank you very much, Council. And just to remind you all, this conversation is powered by Amity Realtors, a real estate agency in Western Uganda. So, Council, as we kickstart today's discussion, which is also very, very interesting, actually, would you maybe just simply tell us what a certificate of title is and what different types of certificate of title are there for Ugandans or in Uganda?
Thank you, Fred. A certificate of title basically is a document. It is a document that proves ownership of land in Uganda. That is under the Registration of Titles Act. It is taken as conclusive proof of ownership of that piece of land that is described therein. I could highlight the key features. The certificate of title has about three key features. Number one, it has three parts. Number one is the title page, then the encumbrance page, and then the other one is the deed plan. On the title page, you are going to have the details of the land, the description, that is the plot number, the block number, and then the volume from which this land is cut, because we believe that land is in a large chunk, but all of it has been plotted and cast on one bigger for us all to refer to and always derive all our other subsequent titles. So on this first page, that is the title page, you're going to find that description of the land, where it is located. Then you'll find the acreage of the land. Usually it is in hectares, but there is a standard way of converting to acres. Then you will also find the registered proprietor of that land. You're going to find the name of the person who is registered in there. That first page has a back page where you can always fill in so many entries. And then it also has a provision for an instrument number. An instrument number is usually on the left corner, on the left column. I think it's the first column usually. That's the instrument number you will find. You'll find, let's say, MBR 001, about 7 or 8 digits plus. I can't confirm, but that is the instrument number. And when you do a search, you will find that when you click on that instrument number, they are going to tell you, it is going to describe that one, this registered proprietor became registered as a result of this instrument number. An instrument is that document that gives the registered proprietor ownership of that land. It could be a lease, it could be a purchase agreement, it could be any other document that gives you title. So that is what is quoted. The moment you submit it in lands, it is given that instrument number. So once you have it, it is put there, and you also find that there is a time, even the minutes upon which that instrument was registered on the certificate of title. Now, key aspect to note there is that once you find something cancelled, every signature of the registrar is usually in double. Something that will be cancelled, there will be another signature that countersigns for any other new entry. There's a cancellation and a new entry. There are always two signatures. One cancels and the next signature registers the next interest on that certificate of title. So when you move on to the next page, first page with the new titles now has a barcode. When you scan that barcode, it should be able to give you the real details on the certificate of title. And that is something that has been added by the ministry to deal with fraudulent dealings and titles that are not genuine. So when you move on to the second page, that is the encumbrance page, that is where you're going to find any other interest in this land that does not emanate from the purchaser or the registered proprietor of this land. These include caveats by people who might have a chibanja on this piece of land, all mortgages where this land is mortgaged, all any other encumbrance. If I give a lease on that land, it will be registered under that encumbrance page. Then the next page is the deed plan, which is basically a map showing the coordinates of your particular piece of land. The particular piece of land is usually highlighted in red. Basically, that is the certificate of title. That is what it is. It is issued in duplicate. That is 2 copies. What you get as an owner is actually a duplicate copy, and what remains with lands is what we call the original copy. So the duplicate copy can also be the owner's copy, but here in reality, that is what we have taken as the original certificate of title. So when we talk about the various types of the certificates of title, they are basically according to the land tenure systems that we have, but basically they all have that same information. The freehold title, it will indicate that it's an FRV, a freehold register volume. So you look out for that. When you see FRV, that is freehold register. When you see LRV, that is leasehold register volume. So you know that this is a lease and this is a freehold. Then we can also have customary certificates of title, and for my colleagues who are in Kampala basically and the surrounding areas, Kampala, Wakiso, you have seen Milo titles also being issued. The other certificate of title I have included amongst the types is a special certificate of title. I'll call it special because later on I'll explain how you come to get it and why you get it, but I've decided to also categorize it as a type of a certificate of title.
Hey, Council, are you there?
Yes, I am there, Fred. I think we can move on to the next concern. And here we can look at one, when we are obtaining a certificate of title, who are the key persons that need to come in?
Council, the line keeps muting. Your phone is muted, Council.
Sorry, Fred, I accidentally muted, but I was discussing the key persons that are involved in the process of acquisition of a land title. Number one is the person owning this land. This could be the purchaser or somebody who has just sold you this land. Both of those people are key persons and they are relevant. The next key important person you need to know is the neighbor or the neighbors of the land that you own or that you want to have a certificate of title acquired for. Then from that, you are going to interface with people of the area land committee. These are available at all the sub-counties and municipalities that we have in the country. And then from that, you will need the chairperson, LC1. After that, you will need also the land board. These are usually at the district. You will also need the physical planning committee. It is also at districts and municipalities. Then the other person that is key will be a staff surveyor, an environmental officer, and a land management officer. Some of these are the ones that form the physical planning committee. But you will also need later on, when you move on, a cartographer and then a registrar of titles. So those of you who have interfaced with these people, these are familiar people, you have heard of these, and you really know what they do. But we are going to discuss in detail what these do. Are we together, Fred?
Yes, Council, we can hear you loud and clear. Please go ahead.
Thank you, Fred, and all our dear listeners. So, moving on, we now need to know what are the steps that you will need to take when you begin applying for a certificate of title or when you're applying for one. Number one, you need to have a land transaction agreement, something that gives you ownership of this piece of land. Here, we talk about a purchase agreement or it could be anything else that gives you ownership of this land. It could be an inheritance document, it could be a will, but of course, when there is a will, you're going to attach a lot of many other things. If you get land under a will, you're going to attach letters of probate and probably a distribution agreement or an inventory that was filed by the administrators or uh, the executors of the will. So once you have that document giving you ownership of land, you are going to fill an application form. This form is filled in triplicate. Filling this form has your details, your name, your occupation, your contacts, and the particular area where you live, where the land is, what you use it for, and then probably the estimate of how big it is. And then it is on this form that you will have uh, neighbors sign for you to confirm the boundaries of your land. So once you have filled this form, you file the application with the area land committee. This area land committee, upon receipt of your application, will verify the facts therein. But also, and key important to note, is that this committee is going to advertise this your application on a notice board within the area or at their offices, and then this will take about 14 days for any other person who might claim an interest in the land that you're applying for or you're applying to bring under the registration of certificate of the registration of titles act. So once these 14 days are passed and there is nobody claiming interest in this land, what will happen is that these people will go ahead and sign the approval of your application, but they must have contacted the neighbors. They actually usually do a physical site and they visit the boundaries in the presence of all your neighbors. The chairman LC1 is involved at this stage. The chairman also one must come in and confirm that actually this is your land and those are the boundaries. So once all that is done, the area committee will then make a report and then submit it. Once they have made that report, you will be required to attach 3 passport photos, your national ID, then, in case of a company applying for a land, for a certificate of title of land, or any other organization, you'll have to have that certificate of incorporation or your articles and memorandum, or any other legal document that proves that you actually exist legally. So once you've done that, then that application, upon approval, will be taken to the fiscal planner, and that is at the district or municipality level. And this is basically the fiscal planning committee, but usually it is manned or chaired by the fiscal planner or the land management officer. So these people will look at your application and then see what you have been using that land for, and then they will grant you that certificate of title. They assess what use you are going to use it for. Is it commercial? Is it farming? Depending on where you are and the plan for this district or this municipality that they have, because we have the Physical Planning Act, and it entitles this committee or the ministry to do a general physical plan for all developments on the land within the country. So they must ensure that your application with certificate of title complies with all those. So once they have done with those compliances, they are going to give you a report. Now, the key aspects here are that usually people apply for certificates of title in wetland areas, in gazetted road reserves, in game reserves, and we keep wondering how this is where the mess comes in. So this fiscal planning committee has people like the land management officer, the fiscal planner, and the environment officer. Usually, these are the people that lead to such errors being made. They are made at such a stage. So unless you interface with these people or they know what they are doing, your application is bound to fail, or you are bound to acquire a title that will later be cancelled for being in a wetland, a road reserve, or any other gazetted place that is not mandated for the use that you may acquire such certificate of title. So from this committee, it will also issue a report confirming that probably your application is commensurate with the land use that you would like to use that land for. Next, you will move to the office of the land board. This is usually at the district, and here it is the secretary of the land board that will receive your application. The board will sit and then consider your application. Given the two reports now that they have, they review, and this is basically a review mechanism at a higher level to avoid fraudulent dealings and any other thing, error that may not have been seen by the previous two committees. So once these are satisfied that your application meets the requirements, they will go ahead and issue what we call a minute that allows you to go ahead and process the certificate of title. In case of any discrepancies or they find any errors, they are going to query your file, and at the worst, they will even go and visit this particular piece of land. Here also is where issues of spousal consent come in. You can actually caveat your application with the office of the land board. You can write a letter and contest that, look, this land should not be brought under the RTA because it is family land and this person is only putting their name, yet I probably contributed as a spouse, or I have an interest being a beneficiary and it is estate land and it is only one person who wants to put it in their names. So once you file your complaint here, it will be handled, it will be addressed, and the process of obtaining certificate of title will be halted until your complaint or caveat is addressed. So once the district land board gives you a go ahead, you will now engage services of the district surveyor who will give you a go ahead to do a survey. But this person must also seek instructions from the ministry to be able to go ahead and do a survey of your part. Now, keep in mind that all along you had not yet done a survey. Right away from the start, from the local area land committee through the physical planning committee, all these were just doing physical sites. Sorry, now at this level, this is when you are going to be able to establish that, look, the land I am actually applying for already has a certificate of title. If you didn't engage services of the surveyor earlier on before you started, it is at this level that you'll be knowing that, okay, the neighboring land has a title that stops here, or the neighboring land actually has a title that went into my land. All these are going to be known at this stage. So once all that is done, then the Secretary Land Board will go ahead and give you what we call an offer to go ahead and obtain a certificate of title. This one indicates now with specificity the actual acreage of your land that you would like to have a certificate of title obtained for. So in cases of lands that are probably a lease and they require consent, still it is these bodies that are concerned. If it is a a lease on government land, it is this board that will give you that authority, that go ahead that will be required. So once that is done, then you will proceed and have your file forwarded to the lands officer, who will in turn have it forwarded to the ministry for onward processing of the certificate of title. Basically, when this file reaches the Ministry of Lands, what we have talked about at the start, describing the certificate of title, is what they will be looking out for. The acreage of the land, where is it located, the owner of the land, how did they come to own the land, and any other encumbrances that may be registered at that time. But for starters, it is usually the information on the first page. Once you have that instrument number, you will lodge your documents, and then the ministry will go ahead and process a certificate of title for you.
Fantastic. Thank you, Council. Ladies and gentlemen, you're listening to Amity Realtors Chats, a conversation surrounding land issues, and all those related issues that many people go through in this country, regarding their land and their properties. Now, tonight we're discussing obtaining a certificate of title, the steps and procedures, and this conversation is powered by Amity Realtors, a real estate agency in Western Uganda. Council Alan, there is someone here who is asking a question in my DM saying, what is the duration of the physical plans that cities and local governments do lay out? And their case in point is, if I bought land 10 years ago for a certain purpose and I did not use it then, is it still valid 10 years after when I want to use that land, or I need to go back to the city authorities?
Thank you, Fred. Most of these plans are usually valid for a period of 15 to 10 years, but they are usually reviewed. So you find that most of the titles that are issued are subject to those plans that were there then. So unless there has been a review, and some of these actually come with development and the need in the area, whatever had been set at the start, due to development and sometimes actually natural disasters, you might find that a city or a municipality may have to review its duration of a plan for a particular area. Thank you.
Fantastic. So, Council, my next question is going to be, and maybe in particular, I know you've somehow hinted on it during the discussion earlier on. What are the key documents, for someone who wants actually to know some of these by fingertips? What are the key documents required in obtaining a certificate of title?
Thank you, Fred. Number one, you must have a national identity card. It is interesting that in Uganda, actually, I think this is the law. It's not just interesting, but this is the law. You are not allowed to own land unless you are a Ugandan. The exception is that you will be given a lease for non-Ugandans. But if you want to hold land in freehold tenure, that is for perpetuity, for everybody else coming after you to hold and give away without any other conditions, you must have a national identity card. So get this national identity card and then get anything that proves that you own this land, that is a land purchase agreement. After you have done that, if you are a company, you must prove that you legally exist for this land to be put in the company's names, because we know as a company it is a separate legal entity and it can own property, be sued and sue in their own capacity. So let's have a look at this certificate of incorporation and your articles. Do your articles actually allow you to own land? So once you have those, you will need 3 passport photos, because we told you that all the applications that you're doing in this process are going to be submitted in triplicate. Then once you have those, you are going to as well get a letter of recommendation from the chairperson LC1, your area chairperson. Now, the fraudulent tendency here is for people to get letters of recommendations from chairpersons that are not of where that area, where that land is actually located. And once that is detected, either at the stage of the area land committee or at the stage of the district land board, the new application is going to be rejected. So the other document that you will need is, of course, the report of the area land committee after doing a site visit and making an assessment. Once they have done that, then they will issue a report to you to go back and confirm to the district land board that, look, we have done an assessment, we've looked at the neighbors, we've looked at the boundaries, saying, and there's no dispute. So that report will also be considered, and it's a key document that you will need. When you go to the Physical Planning Committee, here you are going to require documents like reports of the environment officer, who must confirm after doing an assessment and the site visit that look, the particular piece of land this gentleman wants to register in his own names is not a gazetted place as a wetland, it is not a forest, and it is not a road reserve or any other gazetted places by the National Environment Management Act. So once all those are acquired, then you will be good to go. And the other key document, of course, that this is issued by the Area Management Committee, is the Land Area Management Committee, which is usually a notice to the general public to run for about 14 days after you have filed in your application. So basically, those are the documents you will need. Of course, the others will be issued as you apply. For example, a deed plan after a survey has been done on your land.
Okay, fantastic. Thank you, Council. Now, Council, also something that is always very, very confusing in this process, and sometimes actually it's very hard to tell, are the timelines. Sometimes you find people who tell you, I've spent almost 5 years trying to chase this certificate of title. Others will tell you, I've taken so many years, actually beyond 10, to get my certificate of title. Maybe first, let's start from knowing what are the most common timelines that someone chasing a certificate of title should be expecting within which to get that certificate of title, or also what delays the certificate of title in case somebody has been delayed.
Thank you, Fred. When we go to timelines, the first timeline is going to be uh, the notice. The moment you apply the area land committee, you need to give it about 14 days because this is a statutory period within which they are going to advertise your application and also make their due diligences and consultations at the village level. It starts at the village level because it is believed that information is easy to gather at the village, and within 14 days, anybody knowing of your application can always come up and dispute the same. Once that is done, the land management committee has people who are appointed and usually last 5 years. This is basically their roles. They should be sitting every day, at least once a week, to approve applications. So that is going to probably a third or fourth week, that is within a month, to get approvals from the area land committee. Then you submit to the physical planning committee and then the land management committee of the district. What usually takes long, I will speak out of experience, is at the physical planning committee because usually here is where we find challenges and people are applying for certificates of titles on lands that are either gazetted or border those gazettes, and then somebody concerned, usually the environment officer, has to come and inspect, and then they have to make a report confirming that this piece of land is actually uh, free from the gazetted areas. So you find that in a district there are about 50 applications coming in, and then that is on a monthly basis, and then you realize that there is only one officer to handle all these. So there is, I think, a gap and lack in manpower and spacing because unless these applications are given the key attention they require, that is when we get errors and fraudulent dealings of people obtaining titles on gazetted areas. So once that is done, the rest is basically on a basis of first in, first out. So you find that the other challenge is with the lands office at the ministry or the zonal offices. One, they are adopting a system of online system where everything and every document of theirs that is filed is scanned and uploaded on an online system. So if you bring in your application, it will probably have a minimum of 20 pages, because there's a land agreement, there are your IDs, there's photos, there are other documents, there's a report of the land management committee. All these have to be scanned and uploaded on the system. Being a system that is online, it has challenges with the internet. I will speak from experience. You will go and they'll tell you the system is down, the system is down. And then definitely there is understaffing, because you're going to find a NEMZO serving not only one district, but remember you had 50 applications coming in from a district. So in cases where an EMZO is serving more than one district, I think the minimum is 5 for Kampala and Wakiso. I count the municipalities as districts as well, or the divisions as districts as well. So you find that the minimum is 5, and those 5 usually have, so imagine each has about 50 applications, and you're going to find that at these MZOs, you have only 1 or 2 registrars mandated to sign those certificates of titles. They have to upload everything into the system and then sign on every certificate of title. So the timelines are not stipulated, but that is a picture. It could take you a minimum of 3 months, I could say, with experience, but that is without the very busy schedule or a lot of workload. Thank you.
All right, fantastic. Thank you, Council. I have Herbert, Mr. Tushabe Herbert online. Herbert, if you could unmute your mic before I go to my next question for Council. Herbert, how are you doing?
I'm good. How are you doing, everyone?
We're doing fantastic. Nice to hear you and to hear your voice again. Last time we were trying to get to you, but the network let us down. So today, before I ask Council the next questions, the topic of discussion today is very, very important: certificate of title. But first and foremost, before I actually go on to the hot question I want to give you, what does Amity have? We've just completed the Easter season. What is the hottest that our listeners should know that Amity should have? Maybe they should come for at Amity, just in a minute.
Thank you, Mr. Ugaman and Alan. Thank you for these shows that you have been giving us. They are interesting. Yeah, to get to the question that you asked, Amity, we buy and sell land. Onwards. So we have all these plots in areas of radius 15 kilometers from the Mbarara city center, and they are ranging from 3.5. So whoever wants a residential, commercial, or a farmland, please hit us up. We are on all channels of our social platforms. You can reach us out and we serve you. Thank you.
Okay, great. Now, how about going to the question? We are talking about titles of, certificate of title. And I know that you are in the business of selling land. First and foremost, are you selling plots to buyers without titles, or are you selling plots to buyers with titles, or you're selling both?
Thank you very much. We are selling to our buyers land that is both titled and some that is not. Then we subdivide and help people to attain titles. Like Alan was saying, this process sometimes takes a while because of the bureaucracy in the lands ministry. And most times our hands are tied because of the bureaucracy and the long time that it takes because of what Alan was explaining. But most of our land is titled.
Okay, fantastic. And for those that may want to look out for you, where are your offices located in Mbara?
Our offices are located in the city center on a street called Makansin, and we are on a building called Chosiga House. We are on the second floor, room 305, 306. Whoever is interested has any inquiries regarding land, buying or selling, you can reach us out on our offices. Uh, that's where we are located. Thank you.
Okay, fantastic. Thank you, Herbert. Thank you for the wonderful conversation that you have just had with us. Unfortunately, Council, I think the network let him down. So let me just try to add him back here so we can have the other questions. Council, can you hear me?
Yes, Fred, I can hear you.
Council, can you hear me?
Yes, Fred, I can hear you loud and clear.
Okay, fantastic. Welcome back. So, Council, when you talking to us about the different types of certificate of title, you mentioned something that was very, very important, and it caught my attention. You talked about a special certificate of title, and you said you wanted to also categorize it as a type of certificate of title. What is a special certificate of title in the first place?
Thank you, Fred. When I talked of a certificate of title, yes, I talked of a special certificate of title, and this is issued in instances where the duplicate certificate of title, that is the owner's copy, one you retain, and not forgetting that a certificate of title is issued in duplicate. One copy remains with the land's office. That is what we legally know as the original copy. And then the second copy remains with the owner. That is what we call the owner's copy, or what will be referred to as the duplicate certificate of title. Now, once this owner's copy gets lost, it could actually get lost, stolen, or destroyed through a fire or anything else that destroys certificate of title. All this certificate of title becomes, the word is so obliterated that it cannot be read. Uh, Obliterated is usually arises from the way you have stored the certificate of title. It could be eaten by termites. You know how our grandparents and probably fathers, some of us who are a bit old, used to store their documents. You store your document, you keep it in a nice cloth bag, but before you know it, termites have infested your house or anything, or they are destroyed by water. So, in instances where your title has suffered such circumstances, you are entitled, the law allows you, I think that is section 70 of the Registration of Titles Act, allows you to go ahead and apply to the registrar of titles or the commissioner land registration to obtain what we now call a special certificate of title. The things you have to prove: number one, in instances of unobliterated or destroyed certificate of title, you will be required actually to exhibit this obliterated title or destroyed. If it is partially destroyed, you are required to deliver the pages or remains of this certificate of title. If it is lost, we shall now require you to have a police report. So this will of course indicate the details of your title, circumstances under which it got lost, and a statement that, look, I do not have hopes of obtaining or recovering this certificate of title. So once you have that, of course, they're going to be detailed in probably such a declaration. You will go to a lawyer and the commissioner for oaths, where you will depone all these facts that are led to the loss of your certificate of title. So once you have deponed that such a declaration, you will of course go ahead and file an application with the Commissioner Land Registration and lodge in your documents, which will be considered. Now, the other interesting bit here is that upon lodging in these documents, you are going to be given a notice, and this notice is going to be advertised. Now, if you remember, in the application of certificate of title earlier on at the area land committee, we talked about a certificate, rather a notice of 14 days notice to the public to come and object. In instances of certificate of title, your notice is going to be advertised in what we call the Uganda Gazette. I don't know if many of you here have interacted with the Uganda Gazette, but for ease of reference, this is the official newspaper of government where all acts of parliament are published, and I know this is familiar with you. All MPs that have successfully been elected and declared candidates must be published in the Gazette. So that is the Gazette we are talking about. So the notice you get from the Commissioner Land Registration upon applying for a certificate of title will be publicized or published or advertised in that gazette, and this will run for a period of 30 days. So upon publishing this notice, once these 30 days lapse and nobody has come up to say that, look, I am the one with this person's certificate of title. We do this, or the law provides for this, simply because we are not ready for instances where persons mortgage their lands in other institutions of money lending or financial institutions, and before you know it, they are saying their titles are lost. So those are instances that we avoid when we ask for this notice. So once you return this gazette notice after the 30 days, then you expect your new title to be ready within a period of 10 working days. That I may not guarantee on the 10 working days, but that is what the minister has always assured us. In some instances, it has come even earlier. In some instances, it has come later, owing to the various issues I explained earlier of understaffing and then technological challenges and all that. So, briefly, that is the special certificate of title. However, you have to note that the moment the old certificate of title is found, then the registrar can call for this special certificate of title to be surrendered and cancelled. Thank you.
Council, the phone is muted.
Sorry about that. I had concluded, but
Yeah, you
briefly.
you left us at surrendered. The moment your title, then the registrar,
Oh, I was saying that the moment your original certificate of title is discovered, the one that had gotten lost and that caused you to apply for a special certificate of title, the registrar is entitled to call back your special certificate of title and have it cancelled, because you cannot own two certificates of title. And in case it is not recalled, because in most cases the registrar will not know, then that old certificate of title cannot be presented anywhere. You present it, it will be an element of fraud, because it is you who reported that my certificate of title got lost. You obtain a special certificate of title. But if you transact any other business with the old certificate of title, it cannot actually be admitted at the registry. Once it is received, it is going to be recalled for cancellation. Thank you.
Thank you very much. I have Darlene on online. Darlene, if you can hear me, please unmute your mic. Go ahead with your comment or question.
Thank you, Yugaman. What Council has just explained is what I wanted to ask. The process or under the situations where the special titles can be processed, but I've understood. I wanted to ask something else, but I don't know if it applies here. Council Alan, under what circumstances can a lease title be transferred to a freehold? I don't know if that applies to the topic we have now, but if you could answer that, I'll be grateful. Thank you.
All right, Council, over to you.
Thank you very much. Instances when we can have a leasehold transferred to a freehold certificate of title in respect of much of the land that was owned by individuals, but because of the 1970 decrease of then President Idi Amin that converted all freehold into leases of the citizens. Now, this land, people have been living on it as leasehold. What the government has allowed is that one, upon expiry of your lease, you can now apply to have this land brought under freehold. And the procedure is simple. You do what we call a surrender of that lease to the government, and then you apply. The guarantee is that since you're occupying this land and you have been developing it either through farming or you have anything else or developments, houses, this land will definitely be given to you. So the trick is to always surrender if this lease is about to expire, and then you will get the freehold moving. In respect of the other leases that are not by government, it may not be possible because a lease is an agreement between the landlord and the lessee, or rather the lessor and the lessee, the owner of the land and to the person they are leasing this land. So if it is a church, you're not going to expect this church to probably convert just because you have applied. No, unless there is a termination of that lease and this church actually agrees to sell to you that land on a freehold. So it is not automatic like the leases on the government land. Thank you.
Fantastic. Council, there is another question here on my WhatsApp. Someone has actually been listening in. So they're saying there are instances when you find that you have more than one title on the same plot of land. What causes that?
Thank you, Fred. What causes that is as simple as fraud. I will not attribute it to negligence, but it could be. But in my experience and practice, it is usually fraud. The instances of negligence and honest mistake are indeed rare. It is an element of fraud attributed to all persons we have talked about in that process, right from the area land committee, the purchaser, the vendor, the physical planning committee, up to the register of titles. Sometimes all these people are involved and it is a chain, it is a cartel. Everybody is aware that we are creating a certificate of title probably on another existing certificate of title. So it is a total fraud that we deal with, that we are fighting, that we discourage, and it is not common, but it happens.
Okay, Darlene, I can see you unmuting your mic. Do you have something you want to ask?
Yes, please, Ugaman. Thank
Please
you,
go ahead.
Ugaman, and thank you, Council Alan. Council Alan, I would like to understand one thing here. Can a lease title be subdivided, or it has to be converted into a freehold and then subdivided thereafter? Thank you.
Thank you very much, darling. You are only going to subdivide this lease certificate of title upon consent from the person who gave you that lease. So you're only going to subdivide the lease on what conditions? One, if you are also subleasing. Remember, we'll probably discuss this later in another chat, but for a lease to happen, I have my land. It is probably a freehold. I have a title of my land. So for a lease to happen, I, Alan Musasle, is going to give out a lease to a one Darren. Darren, this lease is going to have a lease agreement. This lease agreement is going to stipulate one, the condition for which I am giving you this land, two, the use for which I'm going to use this land, and three, the duration for which this lease has to run. Usually it is 49 years or 99 years. In instances, you're even given 30 years. You can even have 10 years of the lease, depending on your agreement between the lessor and the lessee. Now, if I have given you this lease, the condition, the paramount condition is you cannot sublease without my consent. So, under what circumstances will you be subdividing? Subdividing means dividing a certificate of title into more than one portions. So you have a certificate of title. Let's say that lease that you have, it is plot 9, it is 9 acres. You are leasing it for farming or you are leasing it for commercial purposes, but you have probably sold off that lease. Before you sell it, you must have consent from me who gave you this lease. So, unless I consent to your sale, can you execute that sale? Meaning, if I do not consent to your sale, then you're not going to be able to subdivide. So a lease can only be subdivided, yes, but under conditions and certain circumstances. Number one, the person who gave you the lease must consent to that subdivision, and then two, it is usually going to be only a sublease that you are going to be able to subdivide. Thank you very much.
Thank you very much, Council. The other question that I got here on Twitter, just a minute, let me try to retrieve it here. Just before we wind up, looks like I've lost it. Council, what are some of the key takeaway points that you want our listeners to part with tonight?
Thank you very much, Mr. Fred, and all our listeners. The key parting shots are one, always document your dealings in land. When I talk of documenting your dealings in land, I mean let us have clear purchase agreements, not these things of recycling and regurgitating. But when you purchase land, have your special terms under which you have purchased this land clearly and categorically written down. If you have contributed to buying of a piece of land, please demand to be part of the purchasers in that land agreement, not only witnesses. This goes to spouses and people in relationships. We have seen a decision of the High Court. They have said, look, we cannot give you property that you own just because you are in an affair. As we are entering into these relationships, let us be mindful of the economic aspects because we live in a world that is full of economics. We can't avoid it. So, unless we document our dealings in land, we are going to miss out. We are going to remain in these land battles forever. Why do I insist on this? Because an application to bring land and a certificate of title will only be granted to a person who probably has that purchase agreement and is indicated as a purchaser. You, my dear spouse, who is not indicated and are only a mere witness, but probably contributed 90 or 70 or 50 or 20 or 30%, but do not appear on this land purchase agreement, you are not an owner of this land. And once this land is brought under a certificate of title, registered in my name as Msasli Alan, it is mine exclusively. It is going to take you a ton of papers, documents, a lot of money, and too much effort from your lawyers to prove that you have interest in this land. But remember, this is something that you could have simply avoided if you took in interest in documenting your dealings with land. Basically, that is my takeaway. And of course, as always, you already use a lawyer, use well-established land dealers. Not every broker is a land dealer. Today, incidentally, I met a friend who was boasting and saying, "Hey, Alan, I am here in a bank concluding a land transaction with my brokers." And then I saw you. And I'm like, okay, you're my friend. You're concluding a land transaction in a bank with land brokers. In my heart, I was like, thank God I have a future client. Good night.
Oh, fantastic. What I can imagine the end of this story, it was going to end in tears. Yeah, but ladies and gentlemen, thank you very much for joining us tonight. And of course, I thank my empowering house, our supporters, Amity Realtors, Herbert and team. Thank you very much. Thank you, Council Alan, for always opening up and sharing this knowledge with our people. And of course, shout outs to Victoria and everybody in area. Yes, Delen.
So to conclude, Council Alan, in case I need more clarity or more information about what we've been discussing and much more, where can I find you? Or do you mind sharing your contact so we can add more, maybe of chat or something? Thank you.
Council Alan? I hope Council is still on the space. Council Alan, can you hear us? Okay. It looks like Council Alan has signed off, probably. But I'm gonna keep that question for the next session. And then definitely, guys, do reach out to me if you want to have Council Alan's number and details so you can get in touch. So Delaney, I hope, unfortunately, Council has, I think, logged off because this is our time. Okay, thank you very much, guys. Thank you for attending. Thank you for always showing up. Our guys, see you again next Tuesday, same time, 8 p.m. And of course, during the course of the week, we'll let you know what new subject we'll be discussing. Now, if you want to listen to the past episodes of this show, please go to the Amity Realtors YouTube channel. You'll catch all the episodes that we've had. Tonight was our 7th episode this year. And of course, you don't want to miss out on this powerful knowledge regarding land conversation. So I'll see you guys again next Tuesday. Cheers, get better, not bitter. And of course, we want you to build a better Uganda by doing the right things. See you guys next week.